Do complex legal issues hold you back? Let's get energized and bring clarity to your top legal questions. This is Law Talk with the Flock by Goosmann Law Firm.
Hello, I'm your host, Jeana Goosmann, a CEO, lawyer, author, and woman business owner, here to help navigate you through the law, your business, and life as a leader. In today's episode, we're going to discuss the current landscape of non-competes and ways you can protect your trade secrets as a business in these competitive markets. So, there's been a big change in 2024 as it relates to non-competes. The FTC has come out with a ban on non-competes in general that is going to go into effect on September 4th of this year. And that has been very controversial. We have had non-competes as long as I've been practicing law, and that has been a big source of protection for companies as it goes to protecting their business information and what makes them have a competitive advantage in the marketplace. So, if there are no non-competes, that changes things in a big way for companies. And I do want to mention there are some legal issues going on with this ban that the FTC has come out with, and a little bit about that. First of all, there are exemptions to the ban, and they have to do with highly paid executives, as well as if there was a business sale transaction and you have a non-compete on the former owner. So that law in and of itself could be its own episode, but I just in general want to just kind of talk about what's going on in the landscape and give you an overview of that. So, since this came out, there are at least three federal lawsuits that are pending around the country in which various organizations, including the U.S. Chamber of Commerce, are trying to essentially fight this ban and get one of the federal courts to issue an injunction nationwide in order to prevent the ban from going into effect. Now, there's legal commentary on all sides on whether one of these judges is going to do that or not, and we will wait and see. But I'm advising clients to go ahead and start to get prepared and act as though the ban is coming into effect because September is not that far away. And then you can always pull back and redirect course if you need to, but at least you will be ready and you won't be caught off guard, especially if you're a business that has non-competes in place with your employees. Now, some of the other things that are really interesting as a result of this are trade secrets. Now, I have done a lot of trade secrets work over my career in various forms, and usually it happens when there's a dispute between competitors, and perhaps there's a breach if there was an M&A gone wrong, and somebody got information from one of the other companies, and then they're starting to use it in the marketplace, and there's some bids that went to the other company, or perhaps some key customers are now with the other company. And also, it comes up a lot with key employees that leave and they go from one company to the other and they take information or data with them. Now, that's where I think we're going to continue to still have a lot of disputes and a lot of legal work in this area, and more so than ever, perhaps, because people are going to be looking to protect their trade secrets. And that's really what people don't want to be used when they want to restrain competition from their current employees going out and being competitors with them, is they don't want those trade secrets. They don't want those customer details going out the door. Obviously, they'd also like to refrain from having another competitor and a skilled one that they trained. But that commentary aside, I think that thinking about this now through a trade secrets lens is becoming even more important. What I have found in the past is that companies typically didn't necessarily identify their trade secrets. A lot of times, companies were thinking of trade secrets in the form of, oh, we have patents or we have IP. But trade secrets are a lot broader than that, and they can be defined in various ways. And there's actually a lot of litigation over how do you define trade secrets and what exactly are they. I've seen cases where employees actually took the standard operating procedure manuals and photocopied them and recreated the binders and gave them to a competitor And I've seen cases where people download things onto their computer or they start to email stuff out to their personal Yahoo, for example, from their computer before they're getting ready to leave. And by the way, attorneys, we have a way through forensic computing of getting access to and seeing how that stuff got saved to the computers. It's just not smart. Don't do that, people. But I digress. As we look at the trade secret issues, a lot of law has been developing, in particular in the trade secrets area, since the Defend Trade Secrets Act came out. So the Defend Trade Secrets Act is a relatively newer law in the last decade that is federal in nature, and it talks about the causes of action and different rights and remedies for companies that are trying to protect their trade secrets or if there has been potentially a breach. And I think that there are some unique things with that that have developed recently in the law that I wanted to highlight here too. One of them is if something happens and you know that it happened and it's happening fast, there is a unique remedy under the Defend Trade Secrets Act law that allows a party to go ex parte and get a seizure of the trade secrets. And that has to be it's a pretty extreme remedy that's actually in that section of the law and the code. But say, for example, you know that the trade secrets are in the hands of someone they shouldn't be, and they're about to leave the jurisdiction. So you're not going to be able to have access to them into the future, or they are going to be destroyed in short order. You could then get a potential order of seizure, and you actually, if you're going to seize these trade secrets, law enforcement can help you with that, even though this is a civil case. So that's what makes that so unique. Some of the things that you would have to show, obviously, are extraordinary circumstances. Some of the ones I just talked about, and you're going to have to put that in your application, support it with a declaration, and the court's going to have to make findings in your favor in that regard. So it's a higher bar than just going to get a temporary restraining order, which is what we've done in the past, because now you're actually going to get to go and do that seizure. Also, you're going to have to show that there's particularity involved with these trade secrets. You can't just kind of go on a big fishing expedition. You have to be able to show what was really taken and how you know it was taken. And I would kind of go down that entire path. But the Defend Trade Secrets Act puts out very specific things that you have to put in your application and then prove up to the court. So for the lawyers that might be listening, I would look that up in the code. It's even been said for those of us that practice in this area, it can be smart to already have a draft application like that ready with a draft declaration, where you would then go forth and fill in your facts and circumstances that are particular to that particular case and matter. Because usually when these things come up, they come up in a flurry. I do recall several times where my team and I had to work until maybe 2 o'clock in the morning to get these sorts of things filed. You get that, 4 o'clock phone call from a client and, oh my gosh, here's what just happened. You assemble your team and you get to work as quick as you can and get it before the court because time is of an essence when stuff like that happens. I actually think that those moments are fun and exciting, and part of what I love about being a lawyer is that rush and that thrill. Obviously, being able to help in a circumstance like that is something that we want to be able to do. Okay, another interesting case and development that's come out this year has to do with a Motorola case. I had a Motorola flip phone when I was in high school. I have a fond memories here from Motorola, but essentially, in a very high level nutshell, here's what happened. There was another company that was accused of poaching 3 of their employees in Malaysia, and they were provided trade secrets and they were using them against them. A jury came out and it was upheld in the Seventh Circuit recently, a $407 million damages award to Motorola as a result of this. Now, that was significant because these are outside of the United States damages and sales that were used to help support that award. And again, the Defend Trade Secrets Act, it's both has civil remedies to it, and now it has been extended to cover foreign sales. There had to be some sort of nexus to that jurisdiction and to the United States, but it was not a very significant one. And I think that that's also interesting as we're more and more in a global environment, and potentially these trade secret issues are occurring globally and not just happening only within the borders of the United States. So one of the other things I wanted to point out is that in general, the Defend Trade Secrets Act has a 3-year statute of limitations, and you have to always be mindful of that when you're pursuing a potential case. Now, there's also whistleblower aspects of the Defend Trade Secrets Act. So if you're an employee inside of a company and you can tell that they're using somebody else's trade secrets, that could be actionable both on a civil or criminal side. And some companies have done a great job of putting together whistleblower programs so that they can investigate that internally before it potentially gets outside of their walls. So lots of unique, interesting things, but I think if you're a business and you are concerned about your what's going to happen now that we can't have non-competes, how can we continue to protect ourselves? It is a great time to talk to your counsel and go through some of these different things. If you're an attorney and you practice in this space, I recommend that you start to maybe put some alerts out there on the different Defend Trade Secrets Act cases. Also, be mindful of every state. I think also has different trade secrets laws. And so sometimes there's state claims and then there's this federal claim under the DTSA. So lots to be thinking about here. Really interesting stuff. One of my favorite areas of the practice of law. And I'm excited that I got to share a little bit about that insight with all of you here today. We'll continue to see what happens with the non-compete FTC ban. And I've also know that there's some pending legislation. If they're able to pass some laws, who knows about that? If they are to strike that ban down in the courthouse, then they might also be able to get some legislation put through that does essentially the same thing. So lots of different things occurring in this area. Very excited to continue to watch it progress and be a part of it. Go have a great day, everyone. Make it worth it.
Thanks for joining us for Law Talk with the Flock by Goosmann Law Firm. We hope you feel energized and ready to soar past your goals. Become a Flock fan and subscribe to our podcast for weekly episodes. Learn more at goosmannlaw.com.